morning, everyone, and thank you for joining us today. My name is Michaela Romesser, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time and talk about how to obtain a green card based on employment. So a few housekeeping items before we get started. So some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US on an E-2 visa and has been on several different visas, including F1, TNB, and H-1B visa. And as such, we know what you are going through during your immigration journey. The firm is a full-service immigration law firm, and we do offer immigration services in a number of different areas, including E-2, E-1, TN, L-1s, and employment-based green cards, and many more. We'll continue to have this webinar series, and we'll do at least 2 webinars a week on a different visa topics. At the end of this webinar, we'll send you out a few useful tools. So we'll be sending this PowerPoint we'll be using during the presentation. We'll send you a link where you can download our guides that go through the visa options in more detail. We'll also send you a link where you can sign up for additional webinars we'll have in the future. And we'll also send you a link to this webinar as it's being recorded, and it will be posted on our YouTube channel. And we do encourage you to subscribe and hit the notification button on our YouTube channel, as we regularly upload immigration videos on different immigration topics. We'll also send you a link where you can set up a consultation in case you would like to discuss your particular situation in more detail. So today we are lucky to have one of our partners, LeGrand Weiner, as the main speaker. And finally, as we go through the PowerPoint, and if you have any questions, you can add them in the chat box or the Q&A box, and we will get to all questions at the end of the webinar. Perfect. So why don't we get started with a brief overview of the employment-based green card categories. So the first green card category is called EB-1A green card. This is for individuals who have an extraordinary ability in their particular field. The standard for this green card is you will have to show that you are one of the small percentage of individuals who have risen to the very top of your field. So, and in case you are interested in this particular visa or green card category, we do have a specific webinar on the EB-1A green card. So we encourage you to attend that webinar. And we also have a lot of YouTube videos about the EB-1A green card on our YouTube channel as well. So the second category is EB-1B, and that is for outstanding researchers and professors. The third category is EB-1C, and that is for multinational executive or managers. And this is kind of a very similar category as the L1 visa. And again, we do have a specific webinar that kind of goes over this. So we encourage you to attend that webinar if you are interested in this category. Finally, this webinar will focus on the EB-2 and the EB-3 green card categories. So for the EB-2 green card category, you have to show that you either have an advanced degree. So this means at least a master's degree or higher, or a bachelor's degree and 5 years of experience, or you have to show that you have exceptional ability. There are 2 kind of subcategories under the EB-2 category. So you can either apply under the national interest waiver, or you would have to find a company in the US that would sponsor you through the PERM process for the green card. And the PERM process will be kind of what we'll focus on at this webinar. The EB-3 category is for professionals, skilled and unskilled workers. And under this category, only the PERM sponsorship is possible. So you would have to find a company in the US that would sponsor you through the PERM process for the EB-3 green card. The next category is EB-4 green card, and this is for certain special categories of special immigrants. One of them is, for example, religious workers. And finally, the final green card category is EB-5, investment-based green card. So for the EB-5 green card, you would have to make an investment in a US business. You would either have to invest $800,000 or $1,050,000, kind of depending where the business is located. And you would also have to create US jobs. And we do have special webinars on the EB-5 green card category. So if that's something you are kind of thinking about or are interested in, we encourage you to attend one of those webinars. Perfect. So now Kelly will take over and go over the labor certification process for the PERM.
Thank you, Michaela. Perfect. So we're going to talk a little bit today about the labor certification process, also called the PERM. And this is the main process by which U.S. employers are able to sponsor, foreign nationals for green cards in the United States. So this is done through the EB-2 or the EB-3 categories. And it is when you're doing a PERM, there has to be a company sponsor. So there's a few categories, as Michaela mentioned on the other slide, that may allow for self-petitioning, like the EB-1A or the EB-2 national interest waiver. But for the EB-2 and the EB-3 through PERM, you do have to have a company, a U.S. employer to sponsor you. And the U.S. company is kind of driving the process. So it's not possible in the PERM context for kind of an employee to self-petition or to be the main person working on this. The company has to commit to that sponsorship process. And it's a three-step process. The three steps are first the PERM, which is by far the longest part of the process and the most involved. Step 2 is the Form I-140, which is a form that's filed with U.S. Citizenship and Immigration Services by the employer to say we want to sponsor this person in this job. And then the last step, the I-485 or consular processing, this is the green card stage. So this is the last step of the process. And more, we are seeing both the EB-2 and the EB-3 categories are what we call backlogs. That means that you might get through the PERM, you might get through the I-140, and then you may have a little bit of a wait before you can file for your green card because there's a backlog in availability of green cards in these categories, worldwide at this point. So let's talk a little bit about each of these three steps. So for the first step, the PERM, the first thing that you do is you need to draft a PERM compliant job description. And what this means is that the job in this context can only ask for the minimum requirements to do the job in a reasonable manner. So most of the time, when a company is drafting a job description, they ask for kind of ideal requirements, right? They might say bachelor's required, master's preferred, or great communicator, great team player. When you're drafting a job description for the PERM to test the U.S. labor market, to see if there's any willing, qualified, and available U.S. workers for this job, you actually can only use the minimum requirements. So if you had to hire somebody, this is what I say to employers, if you had to hire somebody off the street tomorrow to do this job, what would be the minimum things they need in order to do this job successfully? And so once you've drafted the job description, then you're going to file with the Department of Labor to ask for the prevailing wage determination. And so this is the minimum wage that has to be paid at the time the person gets their green card in the future. And the prevailing wage will be based on a lot of factors like the requirements and where the job is located and the wage data based on that. Prevailing wages right now are taking about 6 to 8 months to come back from the Department of Labor. Once the wage is granted, then you can actually start the labor market test. And I think this is what people hear about a lot in the context of the PERM. So the labor market test is where the company actually has to place advertisements. And there's regulations that explain where the advertisements have to be placed. So it can't just be anywhere. It's not kind of a normal recruitment process the company would run. They have to place these ads in at least 2 Sunday newspapers in the newspaper of general circulation in the area of the job, a post with the state workforce agency in the state where the job is located. And then you also have to post a physical notice of filing the PERM at the actual job site. The idea being that other employees at that site should be made aware that, somebody is, that this job is available. And if they want to apply for it, they can. So the recruitment process is usually about 60 days long. There's 30 days, certain of the ads have to be placed for specific numbers of days. So there's usually 30 days where the ads are kind of actively running. And then 30 days of what we call a quiet period where you cannot file the PERM yet and the company doesn't have to actively run the ads anymore, but needs to continue to interview any applicants that apply. So the purpose of this whole labor market test is that they want the employer, before they permanently hire a foreign national, to test the U.S. labor market in the area where the job is located to determine if there's any willing, qualified, and available U.S. workers for this particular job. So during this process, if there is a resume that comes in and they interview somebody and there's just, they meet the requirements, they want the job, they're fine with the salary, like it may be a situation where then the recruitment process has to stop. And then the company, if they want to proceed, can always test the labor market again at a later time. Or sometimes if the company's just gone through a massive layoff, that can impact the ability to, proceed with the PERM. But assuming you kind of test the labor market, you don't find any willing, qualified, and available U.S. workers for this job, then you can go ahead and file the actual labor certification with the Department of Labor. When you file that labor certification, the employer makes all kinds of attestations saying, we placed the ads, here's the dates we placed them, didn't find anybody. You create something called an audit file. And this is all the proof that you conducted the ads, or that you placed the ads, that you conducted the resume review, that you conducted interviews, if there was anyone where it was ambiguous, if they were, qualified. It takes right now about 15 to 16 months to hear back on the PERM, and they can either approve it, or they can deny it, or they can audit it. And so, this is where we have something on the slide called audit triggers. So if your case is audited, it can extend the processing time for this by several months. Usually what will happen is they'll send an audit request. They'll say, please provide us with extra documentation. This might be things like all the resumes that were submitted and the corresponding evaluation sheets explaining why these people were fairly, disqualified from the role. Or it might be proof of the advertisements, the tear sheets from the newspaper and printouts from the state workforce agency website, things like that. And there are certain things that you can have in a PERM that will increase your likelihood of an audit. So one thing is if you require a foreign language, there's a very, very high bar for requiring a foreign language if it's not the type of job where it's clear, like a Spanish teacher. So if you're in a situation where it's, well, my primary clients, are from Turkey, and so I need someone who speaks this language, that often can be very, very tricky for a PERM and make it much more, much riskier. Very often the requirements for a foreign language in that situation are so high, it's kind of maybe not worth it to include, because, you're very much likelier to get audited. Similarly, if you ask for requirements that are far outside what the Department of Labor considers normal. So let's say you asked for, a PhD and 20 years of experience, this is a very, very high bar to meet, much more likely to audit for that, to ask, what is the business necessity for needing that level of experience? So these are all things to keep in mind, at the first stage when you're drafting the job description. This filing for the PERM, it is with the U.S. Department of Labor, so it's not with the immigration agency. It's the Department of Labor that then, kind of works with the immigration agency, to process these. In terms of timing, the overall PERM process from the time you start until the time your PERM is certified, at this point can be a few years because the processing times have gotten so long. So even if if you consider you draft the job description rather quickly, the prevailing wage is taking 6 to 8 months. Recruitment is then mandatory at least 2 months. Sometimes it goes into 3. then the actual processing time for the PERM is 15 to 16 months. So even if we just look at the prevailing wage timeline and the Department of Labor PERM timeline, that in itself is already, almost at or over, 2 years. So it is a process that's taking quite a long time right now. But there are benefits, if you're on an H-1B, and you're at a certain stage of the PERM process, you have an ability to extend. So it is really important to keep those things in mind, your underlying visa status and your overall plan and the timing, because it does take quite a while. Once the PERM is certified, you can move on to step 2, and this is Form I-140. So this is filed with U.S. Citizenship and Immigration Services. This is the only step of the 3-step process where there's an ability to expedite things. You can pay the government a fee to get an answer within 15 business days. Within the 15 business days, it can be an approval, a denial, it can be a request for evidence. And then once that's approved, then you can move on to the green card stage. The I-140 stage has a lot less document requirements than the PERM. So at the I-140 stage, you're essentially proving that the company has the ability to pay the offered wage for the job, and also proving that the applicant themselves meets all the PERM requirements that were in that job description. So if your job description asked for a bachelor's degree and 2 years of experience, you would need in the I-140 to submit the proof that the applicant had the bachelor's degree and the 2 years of experience before joining the PERM employer. Once you get to the green card stage, as I mentioned, you might get to the stage where your I-140 is approved and now you're waiting. And especially, for people who were born in countries with long backlogs like India or China, you may be waiting for several years. But then it is also backlogged worldwide. So everybody is seeing a bit of a wait right now. So when we say, is the timing current or is it not? What we mean is based on the visa bulletin, which is issued each month, do you have the ability to file a green card case? If your case is current, then yes. If not, and your priority date is not current yet, then you would have to wait. And we'll talk a little bit more about I-485 versus consular processing. Both are functionally the same thing in terms of you get a green card at the end of it, but they are quite different processes in terms of kind of where you are and the benefits that you can get during the processing time. Family members can also join at the green card stage. You can sponsor, your spouse and any unmarried children under 21 through the green card process. All right, let's talk a little bit more about the third step, the green card step, and the differences between adjustment of status and consular processing. So an adjustment of status involves filing Form I-485 with U.S. Citizenship and Immigration Services. This is often the most appropriate category for people who have been living and working in the U.S. Their kids are here, they go to school here, their spouse is here, maybe they work. Where it's much more important for them to be primarily in the U.S. And remain here, because when you file the I-485, a large benefit it gives you is the ability to remain in the U.S. and to file for work and travel authorization. So let's say, even if your underlying visa status runs out after you have filed your I-485, you can still stay in the United States. As long as your work and travel authorization are approved, you'll still be able to work and travel. So that's one big benefit, to the I-485 process. At the end of the process, most applicants will have an interview with the USCIS officer. It is possible that the interview is waived, although that we may see more interviews now. And we'll talk a little bit more about the interview process later on in the presentation. For consular processing, this is often appropriate for people that either maybe for some reason, maybe their underlying visa status ran out and there was just no ability to have a different visa status. Or maybe they need to travel all the time and they're not on an H-1B and they're not on an L. And when you're not on an H-1B or an L and you file the I-485, you cannot leave the United States until your travel authorization is granted. And for some people, who either for business or personal reasons need to travel frequently and cannot wait several months for a travel authorization document, sometimes they would go the consular processing route just to give them that ability to continue to travel. If you do consular processing, then after the I-140 is approved, it's sent to the National Visa Center. The National Visa Center will open a case, send a welcome email, and ask for certain fees to be paid. Then the applicant is going to fill out something called a Form DS-260 and submit supporting documents to the National Visa Center. These are things like, passport, marriage and divorce certificates, police certificates for anywhere you've lived. NVC will review the documents and then send the file over to the consulate in the country where you're living, or if you're still residing in the US, the country you most recently lived in before you moved to the United States. You'll then be called to attend an interview at the consulate. They'll ask questions, about the job, about your history. They'll screen, both for, inadmissibility issues as well as kind of making sure that the job is still being offered. And then they get what's called an immigrant visa stamp in their passport. And you enter within 6 months, and then your green card is mailed to you, after you enter the United States. All right. So who can pay for green card fees? So this is a very common question. I think comes up, many people, employees will kind of come and say, well, my employer will sponsor me as long as I pay for everything, and they don't have to do anything. So unfortunately, again, that does not work in the PERM context. It really is a company-driven process. And, from a policy perspective, the government does not allow employees to pay for fees related to the PERM process, and this includes legal fees and other fees. For example, the expenses for placing the advertisements, which can sometimes be a couple thousand, dollars if you're placing in a newspaper that has really high fees. When it comes to the fees for the I-140 and the green card, this can be paid by either the employer or the employee. But for the actual PERM sponsorship process, the employee cannot pay for that. All right, let's talk a little bit about, dual intent. So dual intent is very relevant when you're going through the green card process because ultimately, like if you are on a visa that does not allow for dual intent, like F1, and you have filed for your green card, now you no longer meet the criteria that you do not intend to be in the United States permanently. So if you are on a dual intent visa, that's the ideal situation when you're going through the green card process. Um, when So dual intent visas we've listed here, the H-1B, the L, the O. The O is what we call kind of a quasi dual intent visa. So it doesn't have a lot of the same benefits as the H-1B and the L, but there's kind of less scrutiny on it. Like if you're going through the green card process and you're on an O, it doesn't mean you can't, it doesn't mean you can't kind of get a new O. Although at a certain point, once you file the I-485, it's going to get trickier. Once you file the I-485, the H-1B and the L give you kind of the most benefits in the sense of you can still travel freely and things like that. All right. So we're going to turn it over now to Michaela, who's going to talk to us a little bit about considerations when moving from a visa to a green card.
Yeah, so one thing to look at is kind of like the timing and your underlying visa status. So you should look at how much time is left on your current underlying visa. Some visas are harder to extend or kind of subject to more scrutiny once the I-140 or a green card petition is filed. So this would be what we call single intent visa. So for example, if you're here on a TN visa and then an I-140 petition is filed or a green card petition is filed, then it would be kind of extremely difficult to get the TN extended. So you should kind of look at, are you in the US on a single intent visa or one of the dual intent visas, as Kelly mentioned on the previous slide. Another thing to kind of look at is, do you want to adjust status in the US or kind of do you want to get green card through consular processing? And final, and this is going to be really important for many green card applicant is kind of your family. So do you have any kind of children that will need a green card, and when are they going to be turning 21? So if they are kind of approaching and going to turn 21 soon, then it's going to be good to kind of start the green card conversation with your employer as soon as possible. So you can include them in the applications. Perfect. So what should you consider before your green card interview? So here, just one thing I wanted to mention is that, if you're applying for a green card at a consulate, you will always have to have an interview at the consulate. to get your immigrant visa in your passport, and then you will enter the US on the immigrant visa, and then USCIS will mail you the actual green card on your US address. But if you're applying at a consulate, there will always have to be an interview at the US consulate abroad. If you are applying with USCIS, sometimes USCIS schedules interviews for the employment-based green cards. In some cases, they may approve them without an interview, but it's always kind of good to keep this in mind, that there may be kind of an interview at the end of this process. So how should you kind of get ready for the interview? So you should review the immigrant visa petition, the I-140 petition, and the I-485 petition that were filed with USCIS. As Kelly mentioned, this entire process takes several years, so it's always good to kind of refresh your memory and kind of review the application to see the kind of like the questions on the forms and kind of like what was input on the forms. You should also kind of organize and print all the documents that were submitted to the government. So definitely kind of like print the I-485 petition, like any supporting documents you submitted. You will have to bring, if there is an interview, you will have to bring certain original documents to the interview. The USCIS officer will just kind of take a look at the documents and give them back to you, maybe bring copies of those. They will not keep the originals, but you will have to have the originals for the interview. And generally, those are documents such as, like your birth certificate, if you are married, marriage certificate, if you have kids, birth certificates of the children. So definitely, for those, it's always good to kind of, kind of like assemble those documents like well in advance for the interview. One other kind of important part for the green card is going to be the medical exam. So this will have to be completed both if you are applying for adjustment of status or if you have an interview at the consulate. So just something to keep in mind that at certain stage of the green card process, you will have to complete a medical exam and kind of like submit the medical exam to the government. You should also get an updated proof of employment from the sponsoring employment. So this should be kind of like a recent updated, letter, just kind of confirming that there will be the employment kind of like as specified in the application for you. You should also bring proof of maintenance of status to the interview. So for example, if you are like while the entire PERM or the green card petition is pending and you are in the US on an H-1B visa, you should bring all the, the H-1B approval notice, your H-1B visa stamp, your most recent I-94, just kind of documents showing that you are, you are still in the US, maintaining your underlying status. And one thing we also recommend is to kind of always before interview is to meet with your attorney and do a practice interview just to see, the attorney will have kind of tips, like what are the common questions they ask at these interviews, just kind of explain how these interviews usually go. So these are going to be very helpful. Perfect. So now, what is porting, and can you kind of change, change employers during this process? So porting allows the employees to change employers once the adjustment of status application has been pending for at least 180 days. And the I-140 petition connected to the adjustment of status petition must be approved for the porting to be possible. So that's very important. The kind of the main advantage of porting is that the new employer. So like let's say that you have an I-140 petition approved, the I-485 has been pending for at least 6 months, and you change to a new employer. The main advantage of the porting is that the new employer doesn't have to go through the PERM process, doesn't have to file an I-140 petition. So that's kind of, that process, as Kelly mentioned, takes couple or a few years. So the main advantage of the porting concept is that the new employer will not have to kind of file those two petitions. One thing to keep in mind is that the new employment must be in the same or similar occupation classification as the old employment. So like, let's say that the initial PERM was filed for a position of an accountant, and now for some reason you want to kind of accept the role of I don't know, like a graphic designer, like that will not work because the roles are, obviously not in the same or similar occupational classification. So that's another thing to keep in mind, that the two jobs will have to be kind of the same or in a very similar field. Perfect. And so now, can you change employers after you obtain the actual green card? So, when you obtain an employment-based green card, you are making a good faith attestation to the government that you intend to continue working for the company that sponsored you for the green card. That being said, like there is no kind of amount of time defined in the law as to kind of like how long you have to stay with the employer that sponsored you for the green card. But USCIS, if you do apply for a US citizenship, USCIS will look at kind of your, because you have to disclose your employment history in the naturalization application. So the USCIS officer will kind of look at, like what was the basis, like why did you get a green card, when did you get a green card, and kind of look at your employment history. So like, let's say that you get a green card and then you quit like 2 days later, that would not be an ideal situation. So the general recommendation is to kind of keep working for the employer, that sponsored you for a green card for a reasonable period of time or some period of time after you got the green card, and then you can change employers. Let's say that there is some sort of like a reasonable explanation as to like why you had to kind of change jobs like very shortly after you got the green card. Like let's say that your spouse got a great job offer in a different state and you had to move, or you had a family member sick in a different state and you had to move there. That's a valid explanation. You would then have to kind of explain this at the naturalization interview. But like the overall idea is that the USCIS will kind of look at like how long after you got the green card you stayed with the employer, and if you do leave like 1 week later, like they may ask you kind of additional questions, like what was the reason for that. Perfect. So I don't think we have any questions. So thank you everyone for joining us today, and have a great day.